Clovis is a partner at Covington & Burling, where she is part of their international practice. She advises on international law, treaty arbitration, commercial disputes, and complex litigation. Both GAR and Legal 500 have commended her skills, and she was also a member of CPR's annual meeting steering committee. All yours.
Thank you, Helena, for that welcoming, and thank you everyone for joining this morning. Let me start by giving you a disclaimer. I have never been involved in a mass arbitration claim, but I'm quite interested in the topic, and so I put together this panel to bring you the expertise of the panelists here, which I will introduce. And let me start just by asking you, the audience, who here is dealing with a mass arbitration now? And who is expecting to deal with one in the next year? So let me start with some basics that you're likely already familiar with. What is mass arbitration? It is the filing of hundreds and perhaps thousands of claims at the same time against a single company. And who is exposed? In my experience, every company with a website, and particularly those dealing with user data, could be facing a mass arbitration claim. This means banks, and we have clients who have faced mass arbitration challenges, attacking fees and disclosures. This means technology companies, and most of these claims relate to data privacy issues or advertising issues. And it basically means that every time we scroll through our phones and read very carefully those online terms of use and click, I agree, that company could be facing a mass arbitration claim. And here's why. In the last, I would say, years, arbitration clauses became quite standard in consumer contracts. Why? These arbitration clauses contain what is called a mass claim waiver. So the courts enforce those waivers, and plaintiffs' lawyers reacted quite predictably and effectively by filing mass claims at the same time against the same company and doing so strategically. Why? Because the filing of these claims triggers an obligation to pay massive fees on the company. These are substantial, these are non-refundable, and they are triggered at the very outset, even before a claim is even heard. This can add up to tens of millions of dollars. So what's the result here? You think of claims and their merit, and sometimes it really doesn't matter. The very economic structure of the proceeding, the cost architecture, can drive these outcomes. And this is critical because even though the claims remain separate as a formal matter, collectively they impose significant leverage and intense settlement pressures. And why does it matter? If you're an in-house counsel, you might be faced with a mass claim unexpectedly if you don't have good lawyers on your side. It might be required to make financial decisions very quickly and under intense time pressures. For external counsel, sometimes we are involved at the very outset, at the planning stage, and things unfold in a more orderly manner. But sometimes we get involved when the fees have already been triggered, which means that there are critical strategic choices to be made, and these need to be made very quickly. And institutions, of course, also face significant pressure because you have hundreds or even thousands of nearly identical demands for arbitration, and it's very, very challenging to channel those through an orderly proceeding. So we're here today to give you some practical guidance, whether you sit from the in-house perspective, from the internal counsel perspective, and from the institutional perspective, on how to plan for and how to respond to the threat of mass arbitration claims. That said, the other side of the coin is also quite simple. Some see mass arbitration as a tool for access to justice, as in theory, it allows claims that might not otherwise proceed because they're too small to get a day in court. So this is a battleground, really, between mass arbitration as a tool for access to justice and mass arbitration as abuse of process or even financial extortion. So those two views are out there. They are out there for historical reasons and for strategic reasons and for practical reasons. And the question is, how did we get here and where are we heading? So let me introduce my panel here. And here I need to find my notes. So Mia, I think you already know. Mia is Vice President of CPR Dispute Resolution Services, and she will offer insight into how arbitral institutions are responding to this challenge. Next to Mia, we have Mark Cheskin. Mark is a partner at Hogan Lovells in Miami, and he has decades of experience managing large-scale proceedings, including mass arbitrations. Next to Mark, we have Ken. Ken is president and CEO of FedArb, bringing an institutional and operational perspective on how these proceedings are actually run or how they should be run. And then last but not least, we have two more. Sorry, this is a large panel. We have, of course, Jeff Tai. He's the managing partner of DLA Piper's San Francisco office, and he has firsthand experience successfully defending mass arbitration claims. And last, we have my partner, Erin Thomas, who brings significant experience advising clients on managing and defending against the risk of mass arbitration. I did my best to bring corporate counsel to this table, but unsurprisingly, corporate counsel does not want to be sitting here. They do not want to be targeted by mass arbitration claims, and they don't want to speak about it, or many of them don't want to speak about it.
They also wanted to go to their own panel concurrently.
As Helena encouraged them to do. But we're hoping that this panel will bring diverse perspectives, and we'll start at the very outset where it all begins, the drafting of arbitration clauses. And let me start with Jeff. Jeff, you have been at the front line of this battleground, and more recently in a Ninth Circuit case involving a mass arbitration claim. From your perspective, how are companies drafting arbitration clauses in anticipation of mass filings?
Clovis, thank you, and for those of y'all who were able to make it to today's panel, thank you for being here this morning, as Clovis said, and thank you again for the introduction. My name is Jeff Tsai of DLA Piper in San Francisco, and we do have at DLA Piper lots of matters that pertain to mass arbitration, which has its own kind of nomenclature now, and it's a thing, as you're going to hear about on today's panel, precisely because if you believe, as most people do, that nature abhors a vacuum, then what you have found over time is that companies that have slowly but then quickly started to move away from class action litigation have, as you know, triggered in their terms of use, so we're largely talking about consumer company types of matters, they have put in arbitration clauses. And back in the day, that made a lot of good sense for good reasons. Why would you want a matter that is in the public forum when you can resolve it quickly, confidentially, et cetera, right? People like Ken and CPR and and AAA and JAMS, they do this kind of thing and they do it really well. Where nature abhors a vacuum then is, what do we do in that situation involving lots and lots of claims for those kinds of companies that are trying to avoid that class litigation? And that's where I think plaintiff firms have over time become very clever in how they have dealt with this situation. And what have we found? Exactly why this panel exists today. What amounts to class litigation in arbitral form. What's interesting is that it's difficult to square that circle where you have essentially representative litigation in this kind of arbitration format. And you've seen over the course of a few years a lot of that push and pull in the courts, but amongst the parties too, trying to figure out how to make that particular thing work. So in the course of, to address kind of the primary kind of animating point of Clovis's question, what we have found over the course of years in these arbitration clauses, again, that have largely been geared towards trying to avoid class and representative litigation, is language in the agreement that is what I would call pretty standard pedestrian language. Language that simply says, we're going to go with Fed Arb, and we're going to abide by its rules, and we're going to do arbitration. What happened in the course of that transformation into mass arbitration is this one thing that companies did not quite anticipate, is that while an individual arbitration with Bob Smith consumer makes good and perfect sense, and in fact it's easy, it's economical, what happens when there are 100,000 Bob and Jane Smiths is it changes the game entirely. And that game is changed in the very outset with the initiation of fees that are necessary to commence any kind of arbitration. And that's where you see companies starting a few years ago really starting to question whether or not that continued to make sense. And I think that there have been a few cases out there, and a lot of them have emanated from the Northern District of California. That's my home base in San Francisco. And there is this one case that I wanted to quote to you guys, because I think it really kind of summarizes a lot of where courts have found this issue to have a lot of that push and pull. And then I do want to talk to you about one matter, as Clovis mentioned, that I think really kind of sums up where we are today in this context. And it was a matter called Abernathy against DoorDash, a pretty well-known mass arbitration matter in the Northern District. Judge Alsup, a very well-known district judge in San Francisco. And that matter was exactly what we're talking about. It was a mass arbitration series of claims that were brought against DoorDash in that kind of employer-employee context. And DoorDash made the decision that there were issues it identified with proceeding in this mass arbitration context. And here's what Judge Alsup said. He said, the employer here, DoorDash, faced with having to actually honor its side of the bargain, now blanches at the cost of the filing fees it agreed to pay in the arbitration clause. No doubt DoorDash never expected that so many would actually seek arbitration. Instead, what Judge Alsup called an irony upon irony, DoorDash now wishes to resort to a class-wide lawsuit, the very device it denied to the workers to avoid its duty to arbitrate. What the court said was, this hypocrisy will not be blessed, at least by this order. As you could probably tell, Judge Alsup does not mince words if you've ever had a matter before him. And what that matter highlights, it's a rather kind of amplified example. What it highlights is where you see some of that judicial tension. And so there has been a lot of the shift in the cases that have gone that way. I will say one thing before a quick case I want to mention to you. A lot of what has been happening with companies that have now, with that backdrop in mind, and addressing what is, again, arbitration in a way that these companies never anticipated, is a lot of readjustment that is happening in arbitration clauses to try to create what amount to these kinds of poison pills. That's kind of my description, not something that actually would be said in an arbitration clause, that permits companies to have what functionally is more flexibility in this context. And so there's a lot of, in the very first instance, individualization now that these companies want. And that is those mechanisms that, again, are embedded and built into arbitration clauses to require proof that a claim that is being brought in the context of thousands of claims, in fact, is a legitimate individual claim that that plaintiff's firm is saying it represents. And that's because a lot of that trolling that's been alleged against these plaintiff firms and how they are getting claimants. So that individualization is pretty key. One of the other big kind of mechanisms that companies have been doing is inputting some language in there that allows the companies themselves to be able to kind of step away from arbitration if they want, in order to alternatively proceed in litigation. For example, arbitration clauses that say if there are more than 50, and a lot of the numbers are triggers that you'll see in FedArb, AAA, JAMS in terms of what constitutes mass arbitration. So anywhere from 20 to 25 to 50 will essentially constitute now mass arbitration. But these clauses will say if there are more than 20, then it is going to be mass arbitration under mass arbitration rules. Again, that is an effort to try to avoid the multiples and multiples of fees that otherwise will result. And that takes us to well, actually, let me make one more point, then that'll take us to, I think, a case that kind of sums this all up. Last point I'll mention that a lot of companies have been doing in order to address this mass arbitration issue, and you're starting to see it percolate in the court, so I would urge you to watch this space because you're actually going to see more developments there, is a lot of companies are just refusing to pay the fees. And it's a pretty interesting play. A lot of these companies have been posing issues to the administrator, saying there are various dysfunctions here. We are therefore not going to pay all of these fees, right? In the case of a 5,000 claim mass arbitration. And the reason that's interesting is because, not surprisingly, and without putting Ken on the spot, I invite him to comment on it if he's got something to say about it. I'm sure he does. He's got a lot of things to say about a lot of things. Is that these arbitration providers, in turn, say, then we're not going to arbitrate this matter for you. So it creates this kind of stalemate between the parties. So what have plaintiffs done in response? They have gone to the courts to say, we want to petition to compel arbitration because the arbitration is actually not happening. And in fact, what has happened is that the courts have pretty routinely held that it is not under Section 4 of the Federal Arbitration Act, the role of the courts to opine on those kind of procedural matters. So it creates this kind of very bizarre purgatory for companies, for people who want to arbitrate, for the arbitration providers itself. And there is a recent case that just came out recently called Frazier against X Corp. It's a Second Circuit case where that very issue came up. So let me end with telling you about this case. We had a case, I was honored to be able to serve as lead counsel for it. It was a case called Jones against Stars Entertainment. Stars being, of course, a well-known streaming company. I urge everyone to become a subscriber to Stars. Just ask me. I can tell you plenty of shows that are pretty good on Stars. We represented, in all seriousness, we had the fortune to represent Stars in this matter, and it was a mass arbitration matter, and it's obviously public in the context of the litigation that happened. There were several thousand claims, about 100,000 claims that were made against Stars. It was litigated before JAMS specifically on the issue of whether the matter should be and could be consolidated because it was a filing fee issue. We were talking about on the upwards of $100 million in filing fees versus a consolidated fee for this matter to go to arbitration. The plaintiff's firm did not like the decision of JAMS, which was to say it agreed with our position that it should be consolidated. So they petitioned in the Central District of California challenging that idea. They lost before Judge Cato in Riverside in the Central District, and it was appealed to the Ninth Circuit. We argued that case in Pasadena, and the argument largely came down to this question about whether or not the ability to make that decision, what I'll call that procedural decision to consolidate, was something left to the province of the arbitral provider, in this case JAMS, and the decision was that it was appropriate. And I think that law, that was in early 2025, that decision came out, was important because I think it serves as one important bookend to the opposite case that many in this room are familiar with, which is Heckman against Live Nation, also a Ninth Circuit case that was decided a couple of months before. And that was a case, I'll conclude by saying, that was a very good example where there were, in the eyes of the Ninth Circuit, real procedural and substantive unconscionability issues with how those rules were written that ultimately led to that litigation in the Heckman case. And we can talk today, of course, about Heckman and more about Stars, but those two cases in the Ninth Circuit, as well as that Frazier against X Corp case in the Second Circuit, I think are very good examples of where the law is going, as you're also seeing with where the various provisions are going that companies are trying to implement to address this issue of mass arbitration.
Jeff, in one or two words, what was the most important drafting choice in those two cases?
I'll give you one word, the flexibility. And the reason I say flexibility is in the case of Stars, we specifically did not have language that said it had to be this kind of individualized bilateral arbitration that did not allow for consolidated arbitration.
And let me ask the rest of the panel, what in your experience is that key drafting choice in advising your clients or in dealing with mass arbitrations from a planning perspective?
I mean, I can start with some very basic advice, but I think, and talking from the CPR perspective, just to get this out of the way, we do not administer consumer cases, so our experience with mass claims is in the employment field, where you don't see hundreds and thousands of cases, at least we haven't, I think, thankfully. But you sort of see the lower end where the cases are protocol triggers with 31 cases, and we've seen anything from there to under 200. So it's a much different order of magnitude. But just coming from what I would imagine the drafters should be thinking is to consider what institution you're using, because each institution has different protocols that you can follow. We, of course, have, and we'll talk about this later, our employment-related mass claims protocol, but every arbitral institution has a different mechanism for handling mass claims when they come in, whether they're consolidated, whether there's an arbitrator at the outset who reviews the filing. And so you want to be familiar with those mechanisms and use the mechanism that you think will be best suited to the types of disputes you think you're going to see, whether that's employment, whether it's consumer, small scale, large scale, how it's going to be handled at the outset.
The choice of institutions certainly seems critical, and it touches directly on the cost and economics of mass arbitration. Marek, perhaps based on your experience, could you give us some insight as to how cost shapes outcomes? And in particular, how the fee structures encourage or discourage legitimate or otherwise extortion filings?
Well, there's a lot in that question. I'm going to take a step back. First of all, good morning. And I'm Mark Chesk, and I work out of the Miami office, but probably in the mass arbitration field, the vast majority of what I've done has been under California law. The claimants aren't necessarily in California, but the claims will involve California law. And there is a California law in consumer cases that if the respondent doesn't pay the fees within 30 days of getting an invoice, then the claimants can go into court, seek a motion to compel arbitration, and if successful, the penalties are pretty severe for the respondent, which can include the respondent company paying for of course, the fees of the motion to compel, but also the fees of the arbitration, 100%, including the arbitrator, and at least one court has already held that the respondent has to pay the attorney's fees for the plaintiff's lawyers for challenging the arbitration clause. And so and it also says it could be a default, but I actually haven't seen a case that has done that. And so there are pretty significant ramifications, and California, not surprisingly, is a pretty popular choice of law, or not only choice of law, the laws to sue under. And so in like 2.5 years ago, I had zero mass arbitration experience. In the last 2.5 years, I've personally handled or am handling 15 mass arbitrations. Within the broader privacy group, which I work with a lot, we've had 30. And so we're starting to get a pretty good critical mass of experience. And on fees of the institution, arbitration institution, are incredibly important as to the choice of arbitration clause and for leverage points for claimants' lawyers. And I'm going to speak mostly from the respondent's point of view, is that I'm going to give example here, is if there's 5,000 claimants, and I've handled a case where there was 220,000 claimants.
How many?
220,000.
Wow.
Right. And kind of we're typically in the 5,000 to 10,000.
And what's the filing fee for each?
Okay. Well, I'm going to give 2 examples. So if it's 5,000 claimants, and you're under the mass arbitration rules, I didn't put CPR on employment, I'm sorry, but I know it's.
I can
Fill that in.
fill that in for you.
Yes, I know it's relatively inexpensive. It is relatively inexpensive. Not the arbitrator fees. This is just what goes to the institution, is that for ADR services, it's a pretty negligible amount for 5,000. I calculate around 15,000. JAMS under the mass arbitration rules be 170,000. And for the AAA, 3.8 million. That
Wow.
is just for the right to be able to be within that administrative forum. If you look at 10,000 claimants, again, ADR is relatively inexpensive. JAMS, 335,000, which is very manageable for our clients. AAA, 7.3 million. And so,
That's incorrect, that figure. I'm just letting you know, because I am a process arbitrator for AAA.
right.
As well as CPR, and that's the old paradigm. That is not how it works now. Once you come in, you only pay the process arbitrator until you get to the merits arbitrator, and then the individual filing fee is triggered. So actually, it's less than 20,000.
Okay.
It's still substantial.
Right, it's still substantial, and thank you for clarifying, is that if the arbitration clause is written such it's got to be individual arbitrations, and you don't go through the process arbitration procedure, and if the respondent doesn't want to agree to it, which is a separate discussion, is then the fee structure still is pretty significant. And I am handling a matter now where our clients already paid $1.5 million to the AAA. It's about to get another invoice for $6.7 million.
So it
So,
looks like regardless of institution, the math is quite clear.
That's
It's
right. Yeah,
significant.
And it is correct. And the AAA has adjusted, but the arbitration clauses haven't quite caught up yet. And as a result, one of the initial fights we have is which of the rules apply. And so the claimant's lawyers are arguing that it's when the cause of action accrued. And so if you have a user or you have a subscriber or a customer who's been over the last 2-3 years, you're under the old rules, the old fee structure. If it's, the new rules apply, the new fee structures, it's much more respondent friendly. For JAMS, the arbitration clause has to say that the mass arbitration rules apply. And so with JAMS, I have a constant fight which of the fee structures apply. And so that is what we're seeing as far as that. And so we're seeing all kinds of things in the continue the conversation of arbitration clauses. Batching is when if it's either by the rules or it's in arbitration clauses where 50 cases have to be heard together, 500 cases have to be heard together. Whatever the batch is, and ideally, and now legal arguments to this, but They have to be pretty much the ability to go along at the same time, unless the parties agree otherwise, or there could be some procedural challenges to it. So there's different things now that the companies are adjusting to, and I think it's as a result of the leverage that plaintiffs' lawyers have as a result of these incredible fees, not including the actual arbitrator fees. Because arbitrator fees are pretty much spread over time, typically. So it's really just the filing fees. In every arbitration, I was in a mass arbitration mediation yesterday, where a client, like I said, already paid $1.5 million, is about to get an invoice, and the mediator started out, well-known mediator, very good actually, started out to our client, I understand this is extortion, it's all about the fees.
And Mike, how often do you see settlements driven by that, in your words, extortion, as opposed to the merits of the underlying claims?
It's very common, and it partly depends on the size of the company. A very deep pocket company, I'm talking very deep pocket company, will be willing to bear the fees because they're often the target of multiple different plaintiffs' firms. If you're a medium-sized, smaller company, then it's all about that. Then it's all about it. So it really depends on the stomach of the respondent.
Could I
Ken,
just
any
jump in?
reactions?
Yes, thank you. My name is Ken Hagan. I'm the president and CEO of FedArb, which is an arbitral institution that's been around for 2 decades, headquartered in Silicon Valley. We have 120 arbitrators, mediators. We have the largest panel of Article III judges, and we have a mass arbitration protocol. And so I'm privileged to be on this panel with some of the leaders of the bar on mass arbitration. So Clovis, thanks, and thank you CPR for having me on the panel. Clovis, I think you put your finger on this issue of fees. It's a huge issue. It's been the driver of mass arbitrations. Most of these claims now involve statutory damages. So that's an important point because privacy laws, all sorts of claims that have statutory damages make it very easy for these plaintiffs or claimants counsel to aggregate thousands, tens of thousands, hundreds of thousands of these claims. They do it by TikTok ads, they do it by Instagram posts, and all companies now, I think, are realizing that they are potentially subject to these mass arbitrations. And these are big, big cases with big dollar numbers. Some of the institutions I represent, FedArb, which has a procedure which we think is a very good procedure, but some of the other institutions have rules that historically were generated because of the individual nature of our arbitrations. You bring an arbitration, and then you have a company, and then you have this individual mana type of situation. That, as a result, there are filing fees for each individual claim. And when you aggregate those individual fees, that's how you get these huge numbers, millions of dollars. And so this was a wake-up call to all these companies out there saying, not only am I likely to be a subject of a mass arbitration because of these statutory damages, and the way that the internet now makes it so easy for claimants counsel to buy or to collect tens of thousands of these claimants. So we need to have some sort of procedure here that is economically viable. And in the early days of mass arbitrations, these fees were astronomical because it would be $2,000, $3,000 for each claimant. Some of these institutions have changed their rules a little bit. They've got process arbitrators. They try and defer a little bit. But I put in the presentation materials a recent report that the Chamber of Commerce has put out, and it shows that even under these new rules, with 10,000 claimants, I think the number for AAA is $37 million. For JAMS, it's $16 million. This is getting it through the whole process, right? You've got the preliminary issue, but if you ran this whole thing through, what you're looking at in terms of levels of magnitude. Our process is substantially less. It's $2 million.
And Jeff, can you speak to the specific tools that FedArb is deploying to facilitate management of these proceedings?
Yes. So our process is really to follow the way that the MDL procedures in the federal courts have set up. So we pause everything once a certain trigger is mentioned. So as Mark pointed out, there's a trigger of 25 claims or 50 claims, whatever the claimant, whatever the companies want to put as the trigger amount. And I think it's really important for companies out there to realize the most important thing you can do is to change your arbitration clause to accommodate whatever sort of mass arbitration procedure that you want. Because once those claims have been filed, you're stuck with maybe a procedure that may have worked well in a certain context, but it doesn't work at all in terms of mass arbitrations. Now, you may want to stay with the AAA, but you should at least be aware that there are big costs involved in doing that. You may want to move to FedArb, but you need to know what that procedure looks like. So it's really important before you have a mass arbitration to realize the potential is out there. It's not, for most companies nowadays, it's not a question of if, it's a question of when you're going to be hit by one of these mass arbitrations. And to do your homework in terms of looking at CPR's rules, looking at FedArb's rules, looking at AAA rules, looking at JAM's rules. There are other companies out there, NAM, what have you. Our procedures, to your question, Clovis, is we have an MDL procedure. So everything out there is paused. We don't charge any filing fees until the company has decided they have the option of moving forward with the motion to dismiss, because if they feel that there is not a legal basis for the claim, they can bring a motion to dismiss. They can also bring a motion for Rule 11 sanctions if they haven't complied with their the equivalent of what the federal rules require in terms of verification of the claims based on reasonable knowledge. That's stage one. If they get past that, then there is an MDL procedure where basically all common issues of fact, law, and discovery are adjudicated, and it's binding on all the members of the mass arbitration panel. Especially in California, as we've noted, which is, for better or for worse, been the funnel of all these mass arbitrations. There are now rules about allowing each individual claimant to have individual discovery. That's a big issue that you want to avoid if you're a company. We think that by having an MDL protocol where either a 1 or 3 judge, and for the most part these are former Article 3 judges, decide those issues, that makes it binding on all the parties. If there's going to be a deposition, there's only one deposition, and we feel that that's a cleaner way to proceed. And then those issues become all binding on the people. And one of the things that's really important is if there's companies want to try and settle these cases, oftentimes companies feel like there is this interim effect by having these multi-million-dollar filing fees that they're looking at. And they feel it's unfair that they can't get this in front of a judge and say there's no basis for a claim here until after they paid the filing fees. Because by that time, the cows are already out of the barn. So they want the ability, and we offer that, to say, here's an ability to bring your motion to dismiss, and if the judge says that, or the arbitrator, who happens to be a former federal judge, says that there is no basis for a claim, it's much easier to have a settlement conversation. If the arbitrator decides that actually the claimants do have a basis for a claim, it makes it much easier for the company to come to the table and actually try and settle it. So we think that that positions the parties in a better position, equal footing, to be able to have a meaningful settlement discussion early on.
And what seems to be emerging from the discussion is that not only lawyers, but also institutions are thinking creatively about how to manage these proceedings and how to make them work for companies as well as for plaintiffs, claimants. And we see there's competition between institutions. And what this means is that drafting choices can be very critical, and the choice of institution can really shape outcomes. Let me open it up to the panel for comments. Perhaps Erin?
Yeah, so, thanks, Clovis. Good morning, everyone. I'm Erin Thomas. As Clovis said, I'm a partner in Covington and Burling and handle a lot of mass arbitration cases. I think the work that the institutions are doing to respond to the risk of mass arbitration threats, but also to balance that with the access to justice issues that Clovis has highlighted, are absolutely crucial. And this is something I spend a lot of time talking to my clients about. I have to say one thing that I really appreciate, and that from my perspective as someone who helps clients draft arbitration clauses, is the transparency and the learning and the communication from the arbitral institutions. I mean, so many of the rules, the processes, the procedures, they're being developed and they're evolving in real time. And clients have very granular questions about, okay, so if this goes to a process arbitrator at AAA, what exactly can the process arbitrator decide on? You know, the guidance in the rule is very vague. This is just a plug from a practitioner's perspective to the institutions, as I think the more you can communicate with those of us using your services about what it is actually going to look like, what the options are beyond what's in the rules, and sort of how you're seeing things evolve is absolutely crucial, I think.
And Mia, let me ask you from the CPR perspective and your experience with the mass arbitrations protocol for employment disputes, as you mentioned earlier. What are the critical elements that institutions need to consider in drafting these protocols without compromising neutrality? Because as you can see, how the fees are structured and when they need to get paid and how really shapes outcomes.
Well, so, you know, we've heard from Erin that this is constantly evolving. We've heard from Janice in the audience that how, you know, even you can hear that the AAA has changed their course over time, how they manage these mass claims. And so I think it's essential for institutions to communicate with the stakeholders and figure out, you know, what the needs are and how to craft these processes. So what we did when we were drafting our mass claims protocol, it's our employment-related mass claims protocol, just to make sure we're on the same page, but we put together a task force that included everybody. We had the plaintiff's bar, in-house employment counsel, corporate defense attorneys, neutrals that included arbitrators and mediators, and we brought them to the table to review this process that we were creating so that it could be fair to everybody, which I think is the important part. You don't want it to be fair to just one side, because then it's not really fair. And so the one striking thing that was out there when we started drafting our protocol was this fee issue that's been discussed. And the way we set up our fee schedule was so that, much like what Mark was saying, the arbitrator's fees get seen over time. We wanted to make sure that the institution's fees happened over time rather than all at the outset. So it starts with a lower filing fee, which for us, just to gap fill your prior comments, if it's under 1,000 cases, it's $20,000. If it's over 1,000 to 2,000, it's $25,000. So it's sort of just to get us started with this smaller initiation fee. And then we go forward not with batches, because we've seen in the courts that if you have a really large number of cases and you try to batch them in certain numbers, it's possible to have the proceeding then go on for dozens of decades, at which point some of those plaintiffs maybe aren't even around anymore. So we started with a set of test cases, and it's 10 to 20 test cases depending on, we select 10 at random, and then the parties can add an additional 5 for each side if they think our 10 test cases don't fully represent the group. We have a process arbitrator who can determine if there are objections to the cases being under the mass claims protocol, if there's objections to which cases are being included in those test cases. So we have a process arbitrator who can weigh in on those things before those test cases go forward. And then as they go forward, the filing fees get incurred. Once the 10 test cases end, we essentially pause the arbitration to try to mediate. and we have a global mediator who works with the parties, and they get the results redacted, of course, but those 10 to 20 test cases, they get sort of the decisions redacted so that they see how those first ones went. And then they work with the parties to try to come up with, you know, a global solution. If there's a settlement that's reached, parties can still opt in or opt out of that settlement. If they opt out, they can continue going to arbitration. And those, again, are happening as they happen, as the neutrals are being appointed. That's when the filing fees are sort of coming into play. So it's sort of more spread out over time, and that's something that we really wanted to make sure was taking away that giant sticker shock at the outset. Likewise, if there's no settlement reached, the parties can choose to continue to go to arbitration, or they can opt out and go to court, which was something else that, you know, the parties felt would be fair to allow them, to give them a chance, I've lost my notes, to give them a chance to be able to go to court or to be able to continue in arbitration. And one of the really cool things about our protocol was that it did end up getting sort of reviewed here in California. It's the McGrath versus DoorDash case, where Judge Chen found that the terms of the mass claims protocol appear fair, which I think are like glowing words coming out of the California courts.
Especially from Judge Chen.
So, but so that was what we were, yeah. So that's what we were trying to do there, you know, make sure we had all of the stakeholders, make sure we were addressing the issues. What happens if, you know, the fees are too high, let's spread the fees out. What if, you know, people want to go to court or want to try to find some kind of settlement before proceeding? And so it really took all of the players and tried to find a process that worked at least a little bit for everyone. You can't make everyone happy all the time. But so that's, you know, what we've been seeing institutions doing when the AAA introduced their process arbitrator, trying to maybe follow what we did. I don't know, I wasn't involved, but create these intermediate steps and make processes that are fair to all sides. And I think that is what institutions need to be doing to help, because it is evolving, as we heard. There are constantly new things happening and new ideas that each side is coming up with to try to like get the one over. And so we have to respond to that and make sure that we are helping the process stay fair for everybody and allow access to justice, try to dissuade everyone from abuse of process, and just, you know, keep those matters flowing.
If I can just hop in here, I think that what we're coming back to is the point that you raised, Clovis, that it's important to look at all these institutions and look at the rules that they have. To Erin's point, it's important to understand not only what the rules are, but what the whisper language is in those rules in terms of how that's actually implemented. The bellwether process that CPR has is very different than the batching procedure that JAMS and AAA have adopted, and they're very different from FedArb's rules, which is an MDL process. Each of these have different timelines involved. You know, you go through all those bellwethers, it can take a while. You do batching, it takes a while. We think our process is a lot quicker because it's expedited and it's very narrow focused.
And let me ask the users of the process and these tools, Mark, Jeff, Erin, what in your experience has proven effective? What tools offered by institutions have you have positive experiences with?
I think the early disposition mechanisms, like something like the motion to dismiss you have in FedArb, and also the process arbitrator procedure. To me, those are two innovations that are just incredibly helpful in sort of balancing the interests of all stakeholders in the system.
Yeah, I agree with that. I think that early resolution of common issues, both legal and factual, are pretty critical because they tend to drive early resolution of a lot of these matters, because they will either reduce the cases significantly or they will highlight where resolution needs to happen for a lot of these companies. I tend to find that consolidation in the form of bellwethering versus batching, so bellwethering over batching, is better only because it allows you, I think, to better look at what we're talking about when we're talking about mass claims. We are largely talking about individual claimants for all intents and purposes who are the same. They have virtually identical factual claims. So they don't really need to be, this is just a personal opinion, they don't commonly need to be dealt with in a batching process so much as bellwethering allows for early stage resolution. That's the point that Aaron made, which I endorse wholeheartedly. And then consolidation through bellwethering, which allows, in that kind of second stage way, an ability to make, resolve certain cases that then influence the rest of the claims that still remain.
Thank you. Mark, any reactions?
Yeah, and I think I'm going to speak now from kind of the internal discussions that we have with clients and the internal tensions that our clients have. The in-house lawyers, the in-house litigation counsel is, you know, on one hand, they want to say, I want to do everything individual, which will drive up the cost with any of these organizations, because the plaintiff's lawyers will wear them down. And I don't care what it costs, I'd rather pay whoever, AAA, JAMS, whoever, then I'd rather pay the plaintiff's lawyers. Right, so that they have that. But then we have the discussion on the other side. Okay, well, this is what's going to cost. And so there is that internal tension that I deal with in most of my cases. And you know, I don't want to make the AAA a villain, because actually I'm a big fan of the AAA and these other organizations. It's okay.
We'll give you a seat right here.
Yeah, I know. But yeah, I mean, because, you know, Bridget McCormick, I think, is fantastic. And I think that, who's the CEO, I think that, you know, AAA and the other organizations are all doing their best to make it fair for both sides. So I really don't want to make it sound like anyone is better than the other.
I mean, it's fair for both sides, actually feasible. It seems like institutions are trying to recalibrate and find common ground. But here it's really a math game, from what I'm hearing.
Right. It is.
Anyone in the audience has some first-hand experience that you would like to share?
I can tell you what to put in your clause.
Please do.
Right.
I mean, the first thing is, oh, sorry. Well, I don't need to have the whole conversation.
Well, let me go back to, okay, here's the mic. We'll. Thank you.
First of all, I want to commend Ken, because I think the initial motion to dismiss concept is critical. And as a process arbitrator for the CPR and AAA, I allow that. I always determine, quote unquote, my and AAA's jurisdiction first. And if the person's not a consumer and can't prove to me that they're a consumer, then they didn't sign the terms of use agreement, then they are not subject to arbitration, hence there's no jurisdiction, and I get rid of everybody who falls in that. I cut out over 10,000 claims in that alone. And it's not because I'm pro-respondent, it's because you have to have the right to even be here. And if you didn't sign that agreement, you don't. Then after that, if you want to put in the clause that the arbitrator has, or the process arbitrator, however you want to phrase it, has the authority to determine which is the applicable contract in terms of use agreement, because there are threshold fights. There are a lot of terms of use ones in the old days that used to be extremely favorable for claimants, like if you don't win more than this, we'll pay all your fees or something crazy, because they were trying to combat the legal precedent that it had to be kind of fair to the other side. So if you put in there that the process arbitrator or arbitrator can decide some of these threshold issues, including choice of law, including jurisdiction, including arbitrability, including the decision of the decision maker, because you see Coinbase, where if it's two different arbitration provisions, they're going to argue that the court has to decide that. Well, if it's the two versions of the same contract, I would disagree, right? In Coinbase, it was two different, wholly different contracts, not two versions of the same. But if your contract says the arbitrator has the ability to decide which terms of use, you skirt the whole Coinbase issue. I mean, I have a whole list, so I don't want to hog everything, but I commend that you're giving a venue to some of these threshold issues, which, you know, I routinely address.
Thank you.
Thank you, thank you, thank you for those comments. And please go ahead.
Yes, I'm also a process arbitrator for the AAA. So, but I want to change the conversation a little bit. What are you finding in terms of clauses is giving you the most leverage in trying to make these proceedings appropriately, individual? So, for instance, I've advised clients to put in clauses that say you can't commence an arbitration unless you sent me a, what you might otherwise call a pre-suit demand, and you give the company, 60 days or whatever to try to resolve the matter individually. In other words, to try to drive whatever issues are being raised to customer service and individual resolution, as a way of also, preventing them from being, participants in a mass arbitration. And then there's various other, clauses, that the company has to require to, the ability to require mediation if it wants to. There's some, fee shifting possibilities, so on. Just curious as to find what out there is working or whether none of it is working.
If I can, companies will come and register their arbitration clauses, and they talk through what their arbitration clauses are going to be. The pre-filing fee, before you can file the arbitration demand, you have to have some informal dispute resolution, is something that we have found companies find very effective. And getting back to an observation I made earlier about how a lot of these claims are made as a result of people clicking on a TikTok ad and saying, you're entitled to $6,000 under CCP, whatever it is. If the arbitration says you have to comply with dispute resolution procedures, then to Janice's point, it's easy for her to knock it out and say, you haven't complied. So therefore, these 20,000 claims so as people should know, what happens is these claims aren't individually filed. You get a letter from a law firm, Labaton or Milberg Weiss or whatever it is, and it attaches some cursory information saying, here are 20,000, it's a spreadsheet, 20,000, and that may be all you have are names. You don't have where they're located, customer information. Sometimes you will, sometimes you won't. But you've got very cursory information, and that's how you get to 20,000 or 50,000 in these situations. And so, to answer your question, requiring some sort of information is the easy way for for companies to say, are these real claimants? Sometimes you'll have duplicates. Sometimes you'll have people that were never customers. Dead people. And so this is a way to winnow the funnel, so you really got down to a tangent. Because these are customers. Companies want to do right by their customers. If they violated something, for the most part, they're happy to pay. Not happy, but they're willing to pay. They want to do the right thing, but they don't want to be stupid and paying money to people who are never customers, or paying twice, or paying money to dead people. So
as this battleground unfolds, let me ask Erin, what proceedings are emerging and tools are emerging to deal with mass claims that are beyond arbitration?
Yeah, so I think this discussion about these features that you can include, including pre-dispute exchanges, is a crucial discussion, and I think it's an area that I'm heartened to hear everyone in the room is sort of thinking about it. I think where the stakeholders are catching up. So I think the pre-information exchange, the pre-arbitration, notice requirement information exchange is crucial. And I think it's crucial both to help facilitate settlement if possible, but also to forestall against abuses by counsel. I mean, those letters with the spreadsheet, those are so infuriating to receive, and to have to tell your client that they're looking at exorbitant filing fees for each one of these names on a spreadsheet. I had one the other day in the tens of thousands, and one of the names was, the so-called claimant's name was, I don't know, can you check? Meaning the law firm hadn't even done the modicum of due diligence to see if these are even names of people that they're threatening to bring claims against my client on behalf of, and it's just outrageous. Sorry?
I had Donald Duck.
Yeah, all of that. And so I think forcing the claimant's firms, this is not about like preventing bona fide customers with complaints from having their day in court or in arbitration. This is about curbing abuses by counsel. And so I think having those requirements is important. And I found it very interesting to hear the discussion about, okay, well, what do we do with that? How do we enforce those agreements? So one way, I think, is to give the process arbitrator the authority to deal with that. Another consideration is, like, keep that for the court to decide, right? That it's for a court to decide whether or not the pre-arbitration steps have been complied with. And I think that can be a big disincentive to the less scrupulous claimants firms out there, is if they're going to be hauled in front of a judge and have to explain, why they've discharged their burden on, certain issues of arbitrability that have been reserved for the judge, they may be more hesitant, and that could make your client a less attractive target for mass arbitration. So I'm a big fan of, like, thinking creatively about what you do at that initial stage. The other is I'm a fan of off-ramps built into the process, right? So whether you have a procedure for bellwethers, whether it's batching, there's some point at which the parties can step back and engage in some sort of global mediation with the benefit of your early decisions on bellwether cases or batches, with the benefit perhaps of some early discovery or dispositive motions. Have a global mediation with that information, without the sword of the fees hanging over your head, and also give the parties the option to go to court, to opt out of the arbitration process at that stage. So those are some procedures that we've seen clients express interest in, that I think are effective, that don't put up barriers to bona fide claims, but that can be very effective in combating abuse by claimants' counsel.
Erin, you touched on an important point, which is, when does mass arbitration become abusive, and when does it meaningfully expand access to justice? And who should decide? Should it be the courts, institutions, arbitrators, or market forces? Is it the market price for settlement of these claims, an idea that needs to be embraced? Any thoughts from the panelists?
I continue to think, look, I come to this practice, I know folks come to the mass arbitration practice from a lot of different backgrounds, right? You might be a mass torts lawyer, you may be a class action lawyer, privacy lawyer. I come to it as an arbitration lawyer. So I started doing, sort of individualized arbitration. I'm a big believer in arbitration as an effective and meaningful way to resolve disputes, including consumer disputes. It gives, there's an efficiency, there's a flexibility, there's a cost effectiveness. So I'm a believer in the system working. And I think the courts, and Jeff, I'm sure you have views on this, have played such a crucial role in serving that function. You see the brake sort of put on the process by Heckman. There are bounds beyond which you can't go. So I think that the courts play a really crucial role in striking that balance. And then the work that the arbitral institutions have done to preserve the credibility of arbitration as a method for resolving disputes, that's crucial as well.
And let me ask, perhaps Jeff, are mass arbitrations here to stay?
I think they are, and it's a bit of a follow-on to Erin's point for the following reason. One of the more recent phenomenon that's starting to happen, and it happened even as late as this week in the Northern District of California in a very big MDL matter before Judge Gonzalez Rogers in Oakland Federal Court, is this notion of companies that are proceeding to court on purpose, right? Partly for the reasons that Erin said, a lot of times it makes good sense for something to go to court instead, but then out of the blue in the course of litigation, an offshoot of cases. In this case, in that particular matter, it was the Boy Schiller law firm with several, I'm not sure if it was hundreds or maybe thousands, of claims now triggering arbitration. So you've got this kind of half-pregnant scenario where you are both arbitrating and litigating at the same time. And you can imagine that kind of Schrodinger's cat situation creates a lot of problems, because if companies want one thing, and there is going to be unanimity on this panel about this, they want finality with whatever happens. And that phenomenon, by the way, I'm not about to give you an answer, I don't have an answer to this problem, is that it creates now, when we talk about tension, it creates the actual possibility that you could elect, whether by written provision or otherwise, to proceed in court, but you still run that risk, which then runs opposite to finality, of having arbitration at the same time. So I do think in that way, mass arbitration is here to stay. It's about contouring it to where it can provide that finality, fairness at root, but finality for companies and claimants.
Mark, do you have a solution for the poison pill that Jeff identified?
Yeah, actually, I'm going to kind of make it maybe even worse. Because I am now facing a couple of those, or the offshoots, where there's an ongoing purported class action, and it's an MDL, so the class hasn't been certified yet, and then an offshoot of either hundreds or thousands of claimants bringing in arbitration. So under the terms of use on our clients' web pages, which may or may not be enforceable, because it's not the clicking and all the things, and they're not intended for the sorts of disputes that are going into the MDL. And so, but then you put the companies in a very uncomfortable position of trying to say, well, their own terms of use don't apply. Right? And so that is, pretty much something that is a difficult quandary. And so it's challenging for a company to say in their terms of use that the terms of use don't apply against or for any and all claims arising out of and between the parties. That very broad language is typically used, which then is used against the companies.
The poison pill is here to stay. Any questions from the audience? And we had one back there.
Ken Korea. I also serve as a process arbitrator, but one question is that fee issue aside, isn't mass arbitration still a better option for companies when the other alternative is mass class action that's going to be tried before a jury?
You touched on a very good point, which is that they seem to be looking a lot alike. I welcome reactions.
Companies don't like punitive damages, so that's one great thing about arbitration. Most of these mass arbitrations have statutory damages, so the issues are pretty defined. But yeah, I think that most companies would prefer to have arbitration. They get to pick their arbitrator. It's usually quicker. I think we've had a huge discussion about fees, but I think that is being massaged. It's still not perfect, but it's got to be fixed. But yeah, I think companies, but there are other companies. I think TikTok has, or is it Amazon, got rid of their arbitration provisions and said, we're just going to litigate things. So companies are voting by what their arbitration provisions are. And except for Amazon, that's the only one that I think has said we'd rather just stay in court.
I think you raise a great point, which is that, companies, there's no one-size-fits-all answer, right? And companies should be regularly reviewing their dispute resolution mechanism and figuring out, does this work for the regulatory risk I face, the business risk, the legal risk, the state of the law? I have a client in a highly regulated industry where we have like a quarterly check-in on certain of their website practices and their dispute resolution clauses. And it doesn't have to be a big burdensome thing, it could be like 45 minutes once a quarter. But just to check, and it's sort of a cross-practice team with maybe privacy professionals and disputes lawyers, is this still working? And it's better to sort of stay on top of that on a regular basis than wait for the crisis, right? The 200,000 claimant claim when you realize, I actually didn't opt into the JAMS rules, right? The JAMS mass rules or something like that. So
I think it's it's an assessment of risk, because the risk of a class action of all your consumers or customers or users of a website in California, and the number could be enormous, or a nationwide class action. So they're measuring the risk of the incredible downside of a class action and the legal budgets for class actions if there's not an early dismissal, against the mass arbitrations. And it's a discussion we have after every mass arbitration with our client, says, should we really be doing this? And I'm not advocating either way as far as, because it's a tough decision, but in the mitigation of risk, mass arbitrations, maybe still have some problems that are being worked out, but compared to the overall risk of a class action for some of our clients that survive a motion to dismiss and actually get certified, that's what they're weighing. And I think still our clients are choosing to go with arbitration clauses and are trying to figure it out as the rules evolve and the plaintiff's lawyers get smarter and smarter about these things.
And I imagine reputation also in relationship of these companies to their consumers plays an important role. Let me take another question.
So I am not a process arbitrator, but I am a merits arbitrator, and I have done many mass arbitrations on the merits side. I currently have a bellwether case through NAM. I have a big bunch of batches from another organization. And so my question, both to those with administering bodies and to the advocates, is once we get to the merits part, any thoughts on how can we best help the parties have an efficient process going forward? I realize a lot of the process may have been already set, but what can we do to make this a better process going forward for the parties?
I would say not be afraid to take a firm stance on a procedural issue. Now, the second that came out of my mouth, I'm thinking of a scenario where I don't like the procedural decision and I wish the arbitrator hadn't taken such a firm stance. But, taking control of the process, not being afraid to make a decision, giving the parties clarity on okay, so what is this going to look like, right? And maybe it's not good for the claimants, maybe it's not good for the company, but at least you kind of know what the path is going to look like and take that data into account in developing your litigation strategy and also thinking about settlement opportunities.
So can I follow on that? Sometimes in an arbitration, we will get to a point where there's a disputed issue, and I rule whatever way I'm going to rule, but I then, because arbitration is a different process from proceeding, I then sometimes provide the parties guidance and say, hey, as this goes forward, these are some things I'm thinking about that you may want to address when we face this issue. Is that helpful? Is that befuddling? I thought it would be helpful. I try to, if I were the advocate, this might help me, but we don't get that kind of feedback.
I find that incredibly helpful. An arbitrator who's a black box can be difficult. It's difficult to deal with sometimes. It's difficult to respond, whether it's on merits or on procedure in real time. So I personally would find that very helpful.
And we have time for one final question.
Oh, great, thank you. My question is this: when you settle a class action, every consumer that's in the class who hasn't opted out is bound forever. But you have Milberg come to you with 5,000 claimants. You sit down before you pay that $5 million bill to AAA, and you settle with them because you want to. Milberg can come back the next week with another 5,000. So how do you buy peace without the protection of the class action statute?
That's a great question, and that's a huge issue that we've seen happen, because there's nothing you can do. You can't constrain them ethically. They're entitled to it. You can use moral suasion, and I've heard of cases where people will say, here's a settlement, we want to buy our piece, and we'll give you this number. But two things: one, you have to keep this confidential and do whatever you can to keep it confidential among the claimants group. Good luck with that, because this is a TikTok crowd, and they'll take a screenshot of their settlement payment and say, okay, look, I just got $500 here, and that will foment these people who are out there, just third parties that are collecting all those sort of claimants. You can have better luck, I'm told, and Jeff, you and Mark may have more information, and Aaron may have more information on this, but they usually have luck with claimants' counsel on that particular matter and say, okay, here, we want to buy our piece. sort of gentleman's agreement, this is it. And, you know, the understanding that if you bring a second case, you know, you're never going to get a settlement out of us again. But, you know, I'm not aware of any way you can just cut that off.
Yeah, I will say I think that last part of what Ken said is the very practical of how this works. The reality is there is finality by very explicit design, which is hard to do because the human brain can come up with a lot of different things, but then there's finality through the concept of mutually assured destruction, right? So where you have an enterprising plaintiff's firm, they kind of know they can only go to the well so many times before they want to move on because it increasingly becomes diminishing returns. That's not a super satisfying answer to companies, but that's the version of answer we tend to give. It's the practical reality of what happens. Your Milbergs, your Keller Postmans of the world, they are constantly in search. The only thing better than one good mass arbitration is another good mass arbitration. so they're always in the search of that other one.
Mia, any final reactions from you?
Just going back to what I originally said about, and in our title, balancing the access to justice and the abusive process, I think it's on everybody to play their part. So, of course, you're going to hope that you don't have that abusive process that Steve was just suggesting with claimants sort of coming back over and over again. But it's really on everybody, on the institutions, the arbitrators, the filing parties, defense counsel, to really continue working on solutions and raising ideas and coming up with creative ways to make sure that we can continue to provide the parties, you know, maybe not their day in court, but some way to resolve their disputes while still creating an efficient and an effective process.
And with Mia, our host, closing the session, I thank everyone for joining, and I thank Elena for a great program this week.